Hello, ladies and gentlemen. My name is Mark DiCarlo, and tonight my guest is Mr. Brad Bunting. He's a trust wills attorney. Thank you for coming on and being patient with us.
Thank you, Mark.
So tell me, Prince dies, and Prince doesn't have a will, and Prince has this big estate. Who gets his money? Of course, that's in a different state. That's in Minnesota. Who gets Prince's money?
Well, it depends. I mean, I think I read in the news that it was his sister. I mean, first of all, someone has to be appointed to administer his estate. And his estate is so large that they applied. I mean, I read it in the news that a bank, basically a bank trust company, or his administrator, they're going to make a fortune off of him. I mean, they're going to make, because the estate's $300 million. But he has a very large family. I read there's like 6 or 8 people who are his heirs. But someone in Colorado applied and said that he was Prince's son. I think he's 18 years of age, and they're going to do genetic testing, and if he's genetically related to if he tests positive, then that's who will inherit, will be his child. But also it depends on every state. I haven't seen that he lived with a woman, so no one has come out and said they were
common
his
law
common
marriage.
law. Yeah, common law spouse.
Some states don't have common law, though, too, correct?
Yeah, some states don't. It's different in every state. I mean, Texas has its. We have our own system here in Texas, and in Texas, the rules pretty much provide that if you don't take care of your spouse, the state of Texas isn't going to help you. So unless they changed the rules maybe 10 years ago to where if children are from the same marriage, that the children would inherit the community property. But for the most part, if you're married, if you don't go to a lawyer or otherwise do documents to take care of your husband or wife, the state of Texas isn't going to take care of them for you, except, with one exception, after the Civil War, a lot of widowers were being kicked out of their homes by what were called carpetbaggers from the north, because their husbands had died, and the Texas Constitution basically provides that a surviving spouse can't be kicked out of their home in Texas for the rest of their life. But other than that,
interesting. I was unaware of that.
Yeah, but other than that, or a few other small rights, if you don't take care of your spouse, the state of Texas isn't going to help you.
We were talking briefly before the show about Prince and Prince's will. And one of the things that I said is I think a lot of people don't want to have a will done because they're superstitious. They're afraid that if, in fact, they write the will, that they're going to die. Or it's looking forward. They're superstitious in terms of looking forward to a place that they're going to die. They don't want to admit they're going to die, or they don't want to think of it. So that's why they don't do a will. You think that's true?
I think that's one reason. I think some people are just cheap. They don't want to pay, even though it's very inexpensive to do one.
How much is a will without... Let's say you have 2 adult children, and you have a estate worth maybe $300,000, and and you got an ex-wife. I don't know how much is a will.
Well, generally, I like to say a couple $100, but generally we do most of everything on a package or flat fee basis in our office. Most single people do 5 documents because we don't just will. We do. Other documents for about $750, and a married couple is usually around $1,000, regardless if your estate is small or big, because it's the same amount of work. If the lawyer is actually doing the same amount of work, or if you have a small estate, or sometimes the smaller estates are more work than larger estates, as far as the work that you do. And so it's generally about the same for everybody. It's the one misconception about what you said about being superstitious, I'm going to die, is estate planning in general. It's not about what happens when you die. That's a big misnomer. It's about protecting yourself while you're alive, and that's because your odds of being disabled are 4 to 5 times higher than the odds of dying. And so, I always tell people, someone says I'm superstitious. If I do a will, I die. I would say don't do a will, but protect yourself while you're alive, because if you become disabled, that's when the lawyers make their money. And there was a recent case of this in Corpus. It was a famous man. I told you about Dusty DeRille. So he won $100 million, and they were in guardianship court he ended up dying. I think there were 20 lawyers involved. And
that's a complaint a lot of times, that in these contested cases, the lawyers wind up with all the money.
Yeah, well, they didn't wind up with all the money. because he was so wealthy. But and most of them, it isn't 20 lawyers. It's usually a couple lawyers. It's lawyers for the children. Everyone needs to do basic documents to protect themselves in the event of their own disability. It isn't a one size fits all because every situation is a little different. There are some options you can do. You can do powers of attorney different ways. You can also do a trust. And so it all depends on the individual and their family situation, their circumstances. The easy situation is when you have husband and wife and the children are from the same marriage and they've been married for 50 years. Those are the easy. The more difficult situations, which are much more common now, is blended families. And that's where it comes to my office.
That's a new word.
Yeah.
In other words, you get divorced and you've got a child, and you get remarried and your new wife's got a child. So the families are blended together. Is that what that means?
Yeah, the blended families, and those are the ones that it's not a one size fits all. That's where the your benefit of going to any lawyer that's like done this for many years. I do this area of law. There's about 10 lawyers in Corpus that are board certified in this area. They're all really good lawyers. They're all high quality. It's a very small percentage. There's about 800 lawyers in town. But the blended families, that's where when you get, it really helps to think about what would happen, and there's different ways of approaching it.
So if I to give some concrete examples, so let's say that there's a man that had a child by his first marriage, then he had a child by his second marriage, and he doesn't want to leave his child by his first marriage anything. He can do that in a will.
Yeah, he can do that in a will, but also most property nowadays doesn't go under a will. It goes under other types of accounts. There's such a will phobia or probate phobia out there that most assets, about 75%, are transferred in other types of accounts. For example, someone will go in the credit union and they'll think they're putting one of their children on one of the accounts, but actually they'll set up that account with joint tenancy with right of survivorship or POD to that child.
Paid on death. So if it's paid on death, it immediately goes through to that child without going through a probate or a will.
Yeah, and pay on death works really, really well if it's from husband to wife, and you not worried about the children. But pay on death is a disaster when you have more than one child.
What if there's a contradiction between paid on death and the will? I have an estate at Bank of America. I have an account worth $50,000. It's paid on death to my son. But then in the will it says I leave all my assets to my wife. Does the paid on death?
It's a separate contract, like an insurance policy. So what happened is it doesn't matter what the will says, and the pay on death accounts work, but they cause a lot of family discord after death. I'll give you the most common example, and this is basically in almost every estate. We have the same example. You have a will. It's a surviving spouse. They're alive, or they're leaving property to 3 children. It's mother. She's gone to different accounts because one of the local children is taking care of their child. They'll leave the account pay on death or usually joint tenancy with the child that's local, but the will say all 3 children. Then mom will die, and the other children will see the will says it goes to all 3, and then the child that has the account left to them will then have to decide what to do. Do they keep the money? Because maybe mom didn't even intend to do that. Maybe they were just going to the bank and they didn't understand it. Maybe it was out of convenience. Or do they share with their siblings? And it creates problems 100% of the time, because if they share with their siblings, it's a gift technically, and their spouse may say don't share to them. If they don't share to them, then the siblings may get mad at them because it's not right, because everything was supposed to go 1/3 each. Or even if they share with them, they may resent it later. And so a lot of problems between families that are non-financial are caused because people do very poor estate plans. They're caused by the parents. In other words, you know, people say, oh, you don't know someone until you share an estate with them. But the truth is, it's because the parents do very poor planning, and they create these problems. So
That's right.
Yeah.
I tell my clients a lot of times, well, look, I prefer to have everything in a contract. It's not just to protect you; it's to protect me because I don't want to forget something that I said or told you. So you try to keep it professional, right? And if that's, I guess you're saying, if that's all done correctly, there should be a minimal amount of problems.
Yeah, minimum. The idea is to eliminate the problems before they occur. You can't eliminate all problems because death is such a devastating event. Especially, I mean, I've recently lost my father, and my mother couldn't function after. And so you're dealing with something where if you have poor planning combined with the grief and the irrational behavior that people engage in. It's just lawyers love it, because basically the only people that lawyers make the only cases that lawyers make good money off of are the fights. Everyone knows that. Lawyers don't make a living off the cases that are handled properly. That's just done as a courtesy to clients. Lawyers make money off the problem cases, and so we pretty much do work to do our jobs right, but we also do it because we know the problem cases will come in anyway.
So Brad Bunting isn't going to make much money if somebody comes in and they do the will and the 7 documents, whatever it is, I don't know, whatever it is, $250 to $750 or $250 to $1,000. They're not going to make much money off of that.
Yeah, we don't. We do it, but we love that kind of work because people. It's like you do different kinds of work, and that work is so satisfying.
Right, and it's simple.
And and people are happy. They write thank you notes. So you get non-financial compensation from doing your job right, but you also do the work because you know that when the problem cases come up, they'll also come to you. And the problem cases is what we like. But we don't like doing it. But that's where our living is made. You mentioned about the superstition though, about doing the will. If someone is like that, they have that superstition. I say, well, don't worry about dying. Just make sure that you have the assets for the rest of your life. If something happens to you, you don't end up out on the street somewhere. Take care of yourself while you're alive.
Well, that's true.
I mean, protect yourself, and that's where. True. And because when people don't do documents, their children can fight because they haven't selected, or if they don't have any children, then relatives come out of the woodwork. Relatives they don't know come out of the woodwork and can take over. Or with Prince, it wasn't even a relative; it's some bank that took over his estate. And if he hadn't died, he died. But let's say he was. I think it said on the news he was taking some prescription drugs, or he had something.
Yeah,
let's say for example he didn't die, and it would have been this bank would have taken over his estate, and the bank was okay because Prince is rich. The bank isn't going to take advantage of you. Banks aren't dishonest. The problem that we lawyers have is in Texas we have a very progressive system. All states are different. Oklahoma is completely different. It's very constrictive. It's very expensive. In Texas, we have a system that's very cheap from a legal fee standpoint, but it's a wild west here as far as the states. And so the opportunity for people to do things dishonest is rampant because we have an independent system. We have what is called independent administration. And so if you're executor in your will or your trustee, if they go to the bank with their letter testamentary and they go to the account. And they're supposed to take that account and divide it equally among 5 people. There's really no way for those people to know that account ever existed because of the way our system is set up here. So many times it's not just about doing your documents. It's about being very careful in the selection of the individuals, family members that help you. I mean, that protect you.
Well, the main person, I don't know much about this, but the main person that in the will is the executor of the estate. And the executor of the estate usually is picked in the will, and I think sometimes they get some percentage of the estate to serve as the executor. Is that right?
Well, they can't. In most estates, the executor doesn't charge anything. I'd say the vast majority. They don't charge a fee because you're not going to charge yourself a fee because usually it's the same person that inherits.
Okay. Well,
and also if it's siblings. When you do your documents, you can make a decision. Do you want your executor to be able to charge a fee? Do you want them not to charge a fee? When you draft your documents, if the document allows you to charge a fee, then when you're doing your will, you can select the procedure for compensation.
Okay.
If you leave it blank, which is what you mentioned, yours is the blank. If you leave it blank, then there's an opportunity for a huge fee.
I thought
a statutory fee.
I had specific experience of an aunt who passed away in an East Coast in Maryland, and I think it was statutory regarding the amount of the executor would get if it wasn't in the will.
Yeah, Texas also has the statutory fee,
And I think it was 1%.
In Texas, it's 5%. So, for example, if you have an estate in Texas that is $100,000, let's say $1 million in cash, the statute gives you no fee. But if the estate is $1 million of stock that you executor sells, it gives you a 5% fee, which is a huge fee. So the statutory system encourages executors to sell things they wouldn't otherwise sell just to get a fee, for example. I mean, just to get the fee.
Does anybody ever say, I want Brad Bunting, you as the attorney, to be the executor?
Yes, our office, we serve as executor very, very rarely. It's almost no one wants to be an executor. It's a thankless job. It's only where you have a situation where someone's estate isn't large enough to where a bank can be involved, because banks have minimums. For example, Frost Bank, the banks will want $500,000 to serve as executor. And banks are a good idea. I would prefer selecting a bank and me just doing the legal work. But sometimes when you have individuals that don't have anyone and they don't feel safe with family members, they will select a lawyer to serve as executor. We don't like to do it. I've done it many times. It's a thankless job, and you do it only if somebody asks you, and they don't, and they just want to make sure they're safe. And it's usually someone who doesn't have children, but they've got assets, and they want to make sure that they don't have any family members that would take advantage of them. That's the main concern, is getting taken advantage of when you're alive. You understand? If something happens while you're alive. But
well, you're saying that because it apparently happens very often, where an elderly person is taken advantage of when they're alive. Then
it happens every day. We see it every day. Elder abuse is just. They've even passed laws recently to where they've passed a statute where if a caregiver, it's enormous that show me a senior citizen, and show me 10 senior citizens, and 9 of them have been scammed in some way. And the scams are phone. People call them by phone. They get money out of them. Caregivers. They've recently amended the estates code. That used to be called the probate code, to where a caregiver can't leave them money to themselves, like a lawyer can. Like I can't. Like if it's prohibited in the statute from a lawyer, because from a lawyer doing a will to leave some money to them. Okay, it's prohibited. Okay. But even now, caregivers, there's a statute, because many times caregivers would get people to do. They would present documents to people and get them to sign them, and that's one reason where many times we do things other than wills. When we have someone, let's say for example, you have a single person, they've got assets, they're elderly, we're worried about them getting taken advantage of by a caregiver or family members, they'll do a different type of document. It's called a revocable trust or a living trust. They'll put their assets in that trust. And it's just a document. And then under the document, it'll have how the assets are distributed on death or on disability. So let's say that person, let's say they're being hounded by relatives or someone who says, do me a will, leave everything to me in the will. And let's say they are dependent on those people for food. They're being taken care of them. But let's say they don't want to do that. So they'll put all their assets in the trust, and they'll say, fine, I'll leave everything to you in the will. No problem. Or the document is presented to them along with their food for the day or their medicine to sign. And we talk about with people in private, of course. They can sign that will, leaving everything to that person. But when they die, oops, surprise. Nothing went under the will. They'd already set up things in the trust. And so then those people are really mad, but they didn't know that when the person was alive. So the person gets to know what they do. One of the problems with seniors is pressure being made on them to do their documents a certain way. So when people come to see us, or when people come to see me, you're visiting with the client, you're trying to do their wishes. Sometimes you have to trick people that are around them. You have to not only do you not let them know what they're doing, but you have to present it to where if something else gets signed later, it won't distribute the property.
Well, all that's very interesting. So you do all this. You do the revocable and living trusts, and you do the wills, and you do the life estates, and you do transfer of property, and so on. Contested wills. What's a holographic will?
A holographic will in Texas. Remember when I mentioned about the Republic, the Civil War? People were always allowed to do a will in their own handwriting, and so a holographic will is a will written entirely in your handwriting. So that's why I tell people, let's say someone comes in and says, I'm going to get on the internet and do a will. I say you're better off doing a holographic will than doing it off the internet, because on the internet it may be done incorrectly. They may get a form for the wrong place. A lot of those internet forms, we don't see them very often, but we do. But they're done they're not state specific. They're not saying there's no lawyer to sue if they did a bad job. Or the document, they won't have an executor independent. So I say, if you're going to do a will, write it in your handwriting above getting some form off the internet instead of going to a lawyer. A holographic will is wholly in your handwriting. Another thing that you wouldn't do is you don't type up a will and then don't try and do it yourself, because if you come in and you've got a document that's typed up and then signed, it's not totally in your handwriting. The statute says it has to be totally in your handwriting. So many wills, supposed wills I've seen over the years, people type them up, or they do them on the computer, then they sign them, or they have it notarized. I can't tell you the times I've seen that. They do it themselves, it's been notarized, and it has to be witnessed by two witnesses.
And it's not witnessed by two witnesses.
No. But there was a case here once where I had a will, when I used to do more contested work, where it had one witness and it was notarized, and it was the state of Teal, and it was appealed all the way to the Supreme Court, where one of the local judges, I got him to rule that the notary could, even though it was notarized, that could serve as the witness, and Judge Vargas did that, and it was appealed to the Supreme Court. So technically, if it's witnessed by one and there's a notary thing,
so it was
that
upheld
notary,
by the Supreme Court?
It was upheld that notary ended up being a witness technically, even though the notary didn't sign as a witness, even though it wasn't intended.
Okay.
So
you get that decision published?
It's public. I've only have a few decisions. It's published because it was appealed, and if it was appealed all the way up, and it's one of the its quoted as one of the precedent cases as far as witnesses to a will. I mean, first of all, you shouldn't have a will that does that. That was a homemade will. It wasn't done by a lawyer. You shouldn't have a will.
Why can't you sue like legal? I didn't mean to interrupt you. Go ahead. You
LegalZoom or any of those? Well, because
Zoom.
It says on their website we are not giving legal advice.
So you can't sue them?
No, they're not lawyers. They're not acting as lawyers. It says right on there, we're not giving legal advice.
So one of the reasons I quit doing wills, I was always kind of interested in it. I just never got into it. But I did a few wills, but what you're saying is right. You got to bring in these witnesses, and it's kind of a hassle getting the witnesses. It is, and also another reason to go to a lawyer that works in the area is because sometimes you're not paying if you have a problem case. Sometimes you're not paying for the document or that expertise. You're paying for someone to scare off any contests. You're paying for a reputation. When people call me and they say some problem case, the first thing I ask is who did the will, the absolute first thing, because I want to know who's going to be the witness on the case. And so if you go to someone who does it regularly in the community and you think it's going to be a problem, if you go to someone whose reputation is good for honesty, integrity, and for competence, and they do wills, then that's good. That alone will scare off almost all contests. The name, and so in our office we have two lawyers that are both board certified, and it's one of our. I always say, if I die, I may die tomorrow. So on problem cases, I get the other lawyer in, and that lawyer witnesses too. And it's no guarantee, but just the names will help on problem cases. But problem cases are few and far between. They're very rare. So most estate planning, most documents are just. They're standard couples, single people, and blended families. It would seem like there's The demographic in Corpus Christi, the economic demographic, I would say, is low. In other words, a lot of people don't have money, right? Right? A lot of people in Corpus Christi don't have a lot of money or a lot of money saved.
Everyone needs a will, even if you have nothing, and most wills are not probated. You need your documents. The fallacy, if the will, that there's going to be legal services later, because if you just die with a car and POD accounts.
I get a lot of calls. I get a lot of calls from some of these people, and here's a fairly typical scenario. Maybe Mexican-American family. One of the children is living in a house with the parents.
Well, that's a very common situation.
That's a very common
Yeah.
scenario. And I'm not meaning to say anything racist or stereotypical, but I've seen this. So I'm going to say it. So there might be 5 children. One of the children is living with maybe the mother, and then the mother passes away. No will. So all the children have, I guess it's 1/5 of the house, correct?
After they go to, they don't. The house stays in the mother's name until a lawyer does something. Well, that's a typical case. It's a problem.
Okay,
that's
so
that's
tell us. That's what I'm talking about.
Yeah.
So
well,
tell me.
There's no easy solution to it.
There's no solution.
There's no easy solution.
It's only a $45,000 house to a $55,000.
Well, there's no easy solution to it.
So then you got to go to court. It's a big deal.
Well, there's no executor to evict him from the house. There's nothing in writing that said where she intended that it caused. Those are families.
So could the other 4 children say, "Look, Joe, get out of the house. Get out of the house.
They can.
And we're going to sell the house and divvy up the money." Can they do that?
That's a separate lawsuit. It's extremely expensive. They can. It's a suit for judicial partition or sale. That's an extremely expensive lawsuit. We've done them many, many, many times.
Well, Joe is living in the house, and Joe doesn't want to pay the taxes, or Joe can't afford to pay the taxes. No. Well, I'm not going to pay the taxes. Joe's living in the house. So it's, so if Joe doesn't agree to get out of the house, you got a problem.
Well, usually the kid that lives there in the house, many times they'll do the will leaving that house to that child.
But no, we're saying there's not a will.
If there's not a will, then the family's going to end up being divided later, and you'll have a close family. They go to the funeral, they're all happy. But
so in particular, if there's a house, you got to make certain, even if you don't have any other assets in the world, there should be a will.
Yes, okay. If you have a house.
And let's say that the mother,
if you own a house, yes.
And let's say that the mother had a car.
The car you can take care of without a will. There's a document. It's very cheap to do it. I think so many people.
Well, there's 5 kids and there's 1 car.
Okay.
So how do you do that? And there's no will.
Technically, you can do an affidavit of heirship of motor vehicle. All of them can sign it. All 5 of them can own the car, and they can sell it. But those estates, we don't see that many of those estates on the cars. What happens on the cars is somebody commits a felony and they sign the affidavit of heirship of motor vehicle and then they just transfer it and the cars.
And that's a felony though.
Yeah, I think it's a felony.
But nobody ever finds out about it.
Yeah. Technically, those cars just seem to disappear. The houses don't disappear, but the cars, they seem to vanish. And where's the car? We don't know where the car is. They just gotta disappear. If it's
do you see the stream of cars going down in Mexico sometimes?
Yeah. Someone has
I'm just joking.
Yeah, someone has to transfer the title to the car, and we.
Or do you drive the car without the title?
First of all, lawyers hate estates where there's no will. We hate them. We hate dealing with them. They're just a pain. But many times but sometimes there's shortcuts you can do if the estate is small. If the estate's under $50,000 other than the house, there's a really great procedure. It's called a small estate affidavit that we use to transfer property. It's wonderful because you get a judge's signature without going through an expensive process. If the estate's over $50,000, it's real expensive when you die without a will.
And let's say that you have you die without a will, and there's an account made out to whatever 3 siblings. And you die without a will, and there's only one account that's got $30,000. How do the 3 siblings get the money? What do they have to do to get the money?
If the account is pay on death?
No account paid on death. It was in, let's say, in the father's name.
Oh well, the if there is a whether there's a will or not,
There's
it's the
no
same.
will.
If there's no will, if there is no will, which is what we hate, we hate them. And it depends on whether the account's over 50,000 or not. If it's under 50,000,
$30,000.
if there's 30,000, you can do a procedure called a small estate affidavit, which is something we do every week.
Small estate affidavit.
Yeah, and it's relatively inexpensive. That's where there's few debts, and it's done very often, and it's really the only way to get to those accounts. You can't do affidavits of heirship to get to those accounts. Very few people die without wills, Mark. That's a big fallacy. Because when it comes down to it, most people will do their wills at the end. Very few people actually die without wills. It is very rare. It happens, but people procrastinate. People are suspicious. So you take the suspicious person. You take the superstitious person that says he doesn't want to do a will. He dies. If he doesn't die in a heart attack like that, which does happen, usually people don't die. People usually end up doing wills when they get ill and they start thinking about it. As they get older, and as people get older, that's why our client base are people that are 65, 70 plus. It isn't younger people, because as people get older, they pretty much all end up going to a lawyer. They say they're not going to do it younger. Some of them die when they're younger, and those are the messy cases. But generally, they all end up going to a lawyer, doing it right, and it all gets done without many problems. The messy cases are when people are younger and they die, because those are the ones that die unexpectedly before they do their documents. And those are the messy cases, but they don't happen that often. It happens, but not. I mean, they're pretty rare.
So you do this. You could do a small estate if the account is over $50,000, and there is no will, and there's an account for $100,000. Then what do you have to do?
Yeah. Then it used to be in Nueces County. Nueces County is kind of like the Wild Wild West, in terms of how the courts are set up, and because we don't have a statutory probate court here, we've got four really good judges, but they don't do many probate cases. They do a lot of civil cases and criminal, but it used to be we just we filed for administration of an estate and we got administrator appointed. We used to do that all the time, and it was relatively expensive. However, the local rules here in Nueces County now require. There's a bunch of local rules that require you do an heirship in order to file for administration. And so you're looking at it very expensive even to get started when you have over 50,000 and die with a will. Even to get started, your out-of-pocket costs,
right.
Your filing fees and out-of-pocket costs, and plus your publication fee is about between $1,000 and $1,100. Okay. That's no legal fees.
So if all of them, if there's 4 accounts and they're all 30,000, then you could probably do that affidavit of heirship on all.
No, it has 50,000 total. It's the total estate other than the house on the small estate affidavit. Mm-hmm. The key is you don't put yourself in that position of dying without a will.
But people are. That's why.
But it doesn't happen very often. Because most people end up going to a lawyer or they're doing something. Very few people. Mm-hmm. In practice, it doesn't happen very often. If you look at the cases that are filed, almost locally, almost all of them everyone dies with a will or they die with a trust. Few people die. It happens, but it's low on a percentage basis because people procrastinate, but they end up. Mm-hmm. When people come to your office and they say, that's why in my practice I never rush, I never push anyone, because if they come to their office and they say, I'll come back later, or they just talk, I always know they're going to come back. It may be 10 years, maybe 5 years. I know I'm going to see them. Mm-hmm. It's just a matter of time.
You outlive everybody. You outlive everybody, man. You'll be,
Yeah, I know they're going to come back because people get around to doing things when they want to do it, and women are the driving force. Women are the driving force. There's some rules out there. The sexes are different. It's
not in terms of going to the bathroom.
Well,
all the same.
Yeah,
I'll go to the bathroom.
Yeah, but in terms of documents, it's pretty much guaranteed. Women don't. I mean, if you have a married couple and they come in and their estate's large and they say they say I won't remarry and leave it to the new spouse.
Yeah, right.
And they say that. Well,
right.
Women do not leave property to their new spouse ever. They always protect their kids 100% of the time. So men are what's a good word? Pigs. Men are pigs. Men will remarry and they will disinherit their kids and they'll leave their property to the new spouse. and they will change their wills.
You know, like it's you shouldn't say. You know, you shouldn't say that men are pigs.
Well, I mean,
You know why? You know why?
They will disinherit their
really, you know
children.
why you shouldn't say that? If someone were to say that about women, women are pigs, we'd be say, oh, we're sexist. You're not allowed to say that. But we're allowed to say bad things about men. I kind of resent that.
Yeah.
But, okay.
Let me flip it.
I'm not a pig.
Let me
say, I am not a pig.
Yeah, let me flip it.
Richard Nixon wasn't a crook. I'm not. I'm just joking.
Yeah, let me flip it.
Yeah.
And that's when you have the children from the same marriage. The flip is, I always like to use this one and flip it. When it's a blended family and husband and wife come in and they sit there in front of you and they say, I'm going to leave everything to you, and then after death, you're going to leave it to our kids.
Right.
And then the husband says, I'm going to leave it to you. The wife says, I'm going to leave it to you, and I'm going to leave it to our combined kids. Their men will honor their word. They will keep the stepkids in there. Women, I've had women, they come from the funeral to disinherit the man's kids and leave it all to their kids. And they will actually be the pigs in that instant. Women, in other words, women will change. Men are likely to change if the children are from the same marriage. They will change their wills later. But women will change when there's a blended family. They will almost uniformly change. It's extremely rare they don't change. And so the only way a man can protect his kids when he has kids from a previous marriage is to do something extra. To do something extra to protect his kids. If he uses the basics method, which is trust, it's not going to work in that, because that's the way women and men are made different. Women will make an excuse that he insulted me, he took the golf clubs or something.
So you're going to see some arguments when a husband and wife that have, maybe they're young and they want to do a will, and they're talking about, well, if I die first and you get remarried and you have kids, there's some degree of could be argument regarding what happens in the future or what happens in as you refer to it as a blended family, right?
Yeah, if it's blended family, it goes one way. The women will make the changes later. If it's a nuclear family, the men will make the change if they remarry. And people remarry after their spouse dies. They get with a new, nobody says, oh, I'm not going to meet anyone else, because everyone knows if you've had a parent die, people do remarry after their spouse dies. The question is, how do they change their documents after, or who they leave the property to? So it's not that you're going to get arguments. The only argument would be if the man says, I will never remarry if you die, then there'd be an argument, because the woman would be hitting him and saying, of course you will.
Okay, so I go over to Brad Bunting's office, and I do a will. And Brad Bunting gives me the will back, and it's signed. How, when I die, is anybody going to find that will?
Oh, that's a really good question.
Where is the will at? Does Brad Bunting have a copy of the will? So I get that will, and I put it in a book, in a lot of books that I have, and I die. How is anybody to know that there's a will?
You need to take, whoever does the will, you need to take responsibility for your will. Brad Bunting doesn't.
Brad Bunting doesn't take responsibility for the will.
On very rare occasion, we hold on to originals when it's a situation where the family can't be trusted. But we don't like them. We don't like holding on to originals. The documents belong to the client. We give them to the client. You're responsible for making sure it's safe. There have been many situations where if someone does a will or prenuptial agreement and those documents vanish, they're known to vanish when people find them and they don't say what they say. And it's presumed if the will can't be found, the original, the law presumes it was revoked. So then it's a case. And so if you have a will where someone may be unhappy with what it says, it's your job to keep it in a safe deposit box, or to give it to someone it's going to go to, make sure it's in a safe, you're responsible. If you leave it in your house and it goes to your kids and you remarried and your new spouse doesn't like it, most likely.
She'll just rip it up.
Well, no, she won't.
She won't ever. Away.
It's
the end of the will.
She'll say that she couldn't find it because the law presumes you tore it up.
She'll say that she's lying.
But nobody knows if she's lying or not, because the law presumes if you can't find the original, it's revoked.
Okay.
She may not be lying.
Can you prove up a will? You can law school days, you could prove up a will even though you don't have a will, right?
You can prove up a copy.
What if I was a witness, there's two witnesses to the will. They come in and say, yes, I saw him leave his wife all the money.
You
prove it up orally?
No, you can't do oral wills anymore. That law was done away many years ago.
I'm pretty old.
You have to have a copy, but now there's no shortage of copies because of electronic documents, etc. You have to have a copy. You can prove up a copy. It's done very often.
So I have a will, and it leaves my wife all my money. And then I get that will, and then I leave my wife 1/2 the money, and I initial it, and 1/2 to my son, and then I initial it. Is that a valid will?
You did a new will, or you made a change on the will?
I interlineated as
No,
a
that's
lawyer.
not-
Say
no,
we
that's
cross
not-
it
no,
out,
no, that's
and
not-
I put, and I initial it.
No, invalid.
Is that good?
No.
That's not good.
No, you can't do that. The change has to be done with the same formalities as the original document.
So you have to do a whole new will.
Or amendment called a codicil, a little attachment.
So Brad Bunting does a number of amendments probably to people who change your will.
Yeah, when they change them.
Look, I
I
got remarried.
But we like
Now I want my young wife to get all the money.
But
Here,
yeah,
right? And you do a new will.
Yes, but we've been doing this so many years. We know, with the exception of the type of person who does. There are a few type of people that make a lot of changes to their wills. They make because they get mad at somebody. They make changes, but 99.9% of people won't. They'll only do wills twice in their lifetime. Once when their kids are young and once when they're old. So we do documents to where they're only going to do it once without a major change. But we have in our documents provisions where they can make provisions as to personal property, etc. Because those are the kind of change people make.
Personal property, you mean? So let's say that your mother passed away and she has a house full of collectibles. Collectibles
yeah.
meaning maybe expensive porcelain dolls,
Well,
and
if they're-
Hummel figurines, etc. And there's no will. And there's like, say, 3 children. And then there's this house full of collectibles. Do you have to take that through probate, or the kids could get together? I guess the kids, in theory, could get together and say, look, we're going to sell this stuff and divvy up the money. They could agree to that, I guess, orally, legally, right?
Well, the executor, hopefully the will provides that...
No, there's no will.
Oh, my goodness.
There's no will, there's a house full of collectibles.
That doesn't happen very often. Yeah, if there's no will, then usually it's first come, first serve. By the time the other kids get to the house is empty.
You've seen that.
All the time.
How is that not that? Then you go to the DA's office and you're trying to complain.
They ask the first child, what was in the house when you got there? And they say, it was empty when I showed up. But you showed up within 2 hours. I guess somebody robbed us,
So what do you think of these?
They emptied the house, but Bob's body was still there.
So do you have anything to do with these, I'll call them the kill me papers? You go in the hospital, and you're any age at all, and they want you to sign off saying that, oh, if I'm brain dead, or I want you to kill me, or you could take me off of life support. What do they call that? What do they call the kill me papers?
Okay.
What do they call that when you go in the hospital? They give you those?
They ask you. No, they ask you.
They
ask you for what's called a living will or director's deposition. But really, that's the big misnomer. Is those documents? They're medical documents. That's just a wish, what you want to do. The important document is the medical power of attorney, which is a document which will save your life. Because what happens is, if you have hospitals, the medical professions are so afraid of getting sued, it's safer for them to let someone die than to do something to save them. So what we do get people to do is what's called a medical power of attorney. That's where, if you're in the hospital, it's a document where someone can make a decision to save your life, to approve a procedure.
But that medical power of attorney also gives that person power to kill you.
No. You'll have you can do a separate document that says a living will, which allows your wishes to be taken off life support or intravenous feeding. But in practice, the way it works in practice is those documents that document is not perfect, because even if someone has a living will or not, the doctors are going to those documents are designed to protect the medical profession from lawsuits. That's why they have to be. That's why the living will used to be about 5 sentences, and now it's 6 pages, and it's almost impossible to understand. We change our documents a little bit because those documents are designed to protect the medical profession. So what I try and get people to do is I make sure they do a medical power of attorney, because it can save your life. It can save your life because
Well,
it's smarter for the hospital to let you die than to try and do something that may injure you, and then they don't know who they're responsible to. So it's better for them. It can save your life to have a medical power of attorney because that person can give approval to do something to save your life. We're not worried about end of life.
if they're trustworthy. If they're not benefiting from the will and they want to see you dead.
Well, usually
I've seen that.
Yeah,
I've had personal experience.
Yeah,
with
yeah.
that.
Well, we all do that, but that's rare. If it's that's where you have a situation with someone with no children. If they have children, it's very rare. Their children do not want to see their parents dead. They don't care about the money. It happens, but not too often. But usually, that's where the person without children and its relatives. And they, let's say a brother or sister, they make the decisions, but children make decisions a little different. But as far as it's usually the person making that decision would be the person's benefits. My daughter or my spouse would be named on there. They're getting their property. They're also the person named. You're just going to have to trust them.
Okay, so, but you go into the hospital.
But that document, if you're competent, that medical power of attorney is not effective. It only applies when you're unconscious, and it's only to save your life. The living will is just a document where you're...
Well, they say right away, if I'm brain dead, you could quit giving me intravenous feeding.
That's a separate...
Well, if you could, that's a document that I'm talking about.
Yeah, but the intravenous feeding, people feel both ways about. I mean, for some people, our documents have a little provision where you can initial feed me forever, even if I'm brain dead, and someone else may say, don't feed me. That's a personal preference, and people go both ways on that. Yeah, it's not a one-size-fits-all. Some people want intravenous feeding continued, and some people don't. And there's a third category of people who don't want to make a decision. They don't feel strongly, and they'll let their medical power of attorney do it, the medical agent, because they do trust them. So on the brain dead, people generally don't want to be kept on a machine, but on the intravenous feeding, people go both ways.
Well, it's not uncommon. It's kind of like the deal with capital punishment. It's not uncommon for people who are found to be innocent to have been given capital punishment by the state, and I don't think it's uncommon for people that are in a supposed coma to come out of a coma.
Okay. That's one of my pet peeves. The statutory document on a living will, if you read the definitions, it says if you're in a coma, pull the plug. If you actually read the definitions, but it says irreversible condition terminal. But our documents in all capital nullify that. The ones that I do in my office. So if you go to a hospital and you get a living will, it basically says if you're in a coma, pull the plug. That's the statutory document.
Right.
But in our office,
because you're impliedly agreeing with me.
I agree with you 100%.
Right. Because according to a friend of mine, this EKG and the brain waves aren't. That's not that accurate a test anyway.
People wake up from comas.
Right.
People wake up from coma. So our documents, we have a little addition that says if there's any chance whatsoever of waking up from a coma, that don't pull the plug.
Well, and that this is related to the what's called the culture of life or the life issues within the Catholic Church and regarding when somebody should die or when they should be permitted to die and all this. That's why I'm asking some of these questions. It's kind of interesting. But I'm sure within your practice you've seen some. Haven't you seen some questionable practices? Maybe somebody who should have been kept on feeding
generally,
was denied. I'm sure you've seen that.
Yeah, generally we don't really get involved. Generally, the only thing we see is people get angry because they feel doctors don't obey living wills. They feel like they don't pull that. See, a will is different. It's a set document. It says who you're leaving your property to, and it has an executor. That document is an imperfect document because it's a request to medical professionals. So generally people will complain they didn't honor my dad's living will.
Right.
They kept him alive. They didn't honor it.
Right.
You have to explain those documents. You can't sue the medical professionals for not honoring it. It's a document. It's, for example, it's like the HIPAA, which is the other document too. People do a HIPAA. There's a law, HIPAA privacy law. And it's a document that says even if you do a medical power of attorney, you can't release any medical information. It's been in effect for over 10 years without the authorization. So people in our office, they sign a HIPAA when they do a medical power of attorney. Reality is the medical profession, they give out information without HIPAAs.
All the time.
All the time, unless they're trying to do a cover-up. In which case they say, do you have a HIPAA?
Right.
Let's say mom gets hurt in the hospital, and that's not my area of practice, and let's say you want information, and they say, do you have a HIPAA? I have a medical power of attorney, but do you have a HIPAA? So the HIPAA allows the hospitals to close rank and to prevent information from coming out inexpensively. And so all those documents that people do, you have to understand those 3 documents, which have nothing. They came into being because of the medical. The lobbyists got them all passed. They were done by, the lobbyists got the laws passed, and they amend those statutes all the time. Those documents exist to protect the medical profession. It's just like tort reform, just like the $250,000 cap on suing. You can't really sue anymore. You can't really sue medical doctors anymore.
You could maybe if the person, you could sue medical malpractice maybe if the person's young enough and they were a high wage earner, I believe, because then
I don't know. Yeah, but I know that
for wrongful death. But if
yeah.
somebody's a senior citizen, their life is worth so little you can't hardly sue in the state of Texas.
So those documents, they exist to protect the medical profession, but you still need them, maybe modified a little bit. So you still need them because.
How many documents do? Go ahead.
Oh yeah, you still need them because you may need some help, and someone may need to authorize a procedure, and without one, they'll just let you sit there. Because no one's because no one is authorized to approve a procedure if you're not conscious.
And how many documents? If I went in, if the husband and wife, let's say 42 years old, go into your office and they got 2 children, how many documents would you recommend that they fill out? They got a HIPAA, and then they got the will, then they got a living power of attorney, then they got.
Most people do 10. It's 5 each.
10 documents.
It's 10. It's the will. Yeah, most people do 10. Because it's you do, and this is a simple. First of all, the 42-year-old doesn't come in too often. It's usually the 82-year-old.
Okay.
But you do a will and you do a medical power of attorney. You do a power of attorney and you do a HIPAA and you do a living will. And so usually it's 10 documents total. But those documents involve little decisions that you have to make. In other words, it's not a form. You have to make some little. People say, "Do you have a form?" Yeah, there are forms for the medical documents, but on the others, there's some judgment decisions that you make when you're doing them, and that's where really when you're going to see someone, you're paying for you're paying for not so much the expertise, you're paying for someone who's seen the situations, and they can say, well, I can't make guarantees your family won't fight, your children, but I can tell you based on our experience, if you do this, they're almost guaranteed to cause problems, and if you do this, it's less likely. But usually it's 10 documents for a married couple and 5 for a single person. And for most people, but a lot of people do more. They do a living trust. A lot of people do a living trust. I have a living trust. It's the best thing. My parents have one, and my father recently passed away. And so sometimes you do other documents.
So a living trust incorporates everything.
Yeah, a living trust is just an additional mechanism or method of administering estate.
Let's say in a state of $800,000. Excuse me for interrupting you. You want to do a living trust. How much money do you charge?
Oh, it totally. We don't do that many. It totally. That's something you can't quote fix because it's a situation specific. Because basically you're pre-probating the estate. You
can't say this is going to cost you between $1,500 and $3,500.
Yeah, it will never cost $3,500, but maybe $1,500. You can't. Yeah, you can't on those documents. Okay. On the wills you can quote a set amount because the work is done after death. On that you have to look at the work in advance before you can say. But
you've never done one that costs as much as $3,500.
No, I don't remember. Well, I've done some. I've done them with like 200 properties. I've done them when like some people own 200 houses and they'll transfer everything in there. And so that's a lot of real estate. That's a lot of deeds. So that's a lot of legal descriptions. And so you can, or someone that has like 30 accounts. So there's a lot of work involved.
It must be somebody who's passing away.
So but there are other things. There are other things that people do. I mean, lawyers that do this kind of work, we don't just do wills. And we don't just do living trust. We do other things, other than that. We do partnerships, things of that nature. A lot of people have small businesses. Corpus Christi.
We do PLCs, professional limited liability companies.
So it's
all
a situation. But really, you're trying to you're trying to help people with the occasional funny story. I mean, it's like you see things over time. You say every time you say you've never seen anything, you haven't seen. You see something new. I had one that I like to tell. This guy was a very wealthy man, extraordinarily wealthy, and he had 4 wives when he died.
Different.
Well, no, he figured
Was
it
he a
out.
Muslim? Was he polygamous?
No, he figured out it was very easy to get married and not very easy to get divorced. And so at the time of his death, he had a wife in Italy, one in Argentina, one in Canada, and then the Corpus Christi wife. However, Texas has a law called putative spouses, where even if there's multiple spouses, Texas really protects you if you in that, and so that
very interesting. Yeah.
So every time you see something, you're never going to see.
So here's what I come in. I'd represent one of the Texas wives. I'd say something like, well, I don't know. No, that wouldn't be in her interest. I'd say, well, he's a criminal. There's no will. I'd say something like that. He's a criminal that can't. Criminal can't.
What do you mean? I'm not sure.
I don't know. Can't you bust a will somehow? Well,
that's someone without a will. In that case, I don't think they had a will. Maybe it was holographic. But you see in practice, you see funny things, and then part of part of this practice is trying to keep families from fighting. That's part of the job. Part of your job is trying to prevent family fights. The ones that you hear about, these horror stories that you hear about, which do occur. 90% of the time,
I'm sure there's resentments that come out during these deals. You didn't see mom and pop for 12 years. I'm sure there's a lot of resentments that come out. Why should you get anything? Blah blah blah. I'm sure there's a lot of personal animosity and resentment that come in.
Yeah, and a lot of it is also because people. Things happen, things that happened when they were 10 years old, they resurface when they're 60. The things just come out of the woodwork. And so, but it's the parents' job to do their documents in a way to try and minimize that or prevent that.
Well, I wanted to thank you. This has been Mr. Brad Bunting, estate, probate, wills. Brad Bunting in practice here, 30 years or so?
30 years, yes. 30 years.
Maybe we'll get you a little medallion or something for that. Thanks for coming on.
Thank you so much. Thank you for having me here on your show.
Bye-bye.